Greetings, respected guests, and welcome to the Washington Center for the Performing Arts. Today's event is not intended to be partisan in any way. Sponsors for this event include Olyarts Magazine, Browser's Books, the Northwest Playwrights Alliance, TC Media, and the Washington Center for the Performing Arts. Over the course of the day, a variety of readers from our local government and community will be reading 30 minutes of materials from the document known as the Mueller Report. Each reader has been asked to present the material without commentary, and transitions between speakers will be very brief. When a reader comes to a section of text that has been redacted, they will indicate so by ringing a bell. We hope you find this information useful and enjoyable.
The office, therefore, did not charge any individual associated with the Trump campaign with conspiracy to commit a federal offense arising from Russia contacts, either under specific statute or under Section 371's offenses clause. The office also did not charge any campaign official or associate with a conspiracy under Section 371's defraud clause. That clause criminalizes participating in an agreement to obstruct a lawful function of the U.S. government or its agencies through deceitful or dishonest means. See Dennis versus United States, 384 U.S. 855-861, 1966, Hammerschmidt versus United States, 265 U.S. 182, 188, 1924. See also U.S. States versus Concord Management and Consulting, LLC, 347 F Sup 3D38, 46 DDC 2018. The investigation did not establish any agreement among campaign officials or between such officials and Russia-linked individuals to interfere with or obstruct a lawful function of a government agency during the campaign or transition period. And as discussed in Volume 1, Section VA Super, the investigation did not identify evidence that any campaign official or associate knowingly and intentionally participated in the conspiracy to defraud that the office or charged, namely the active measures conspiracy described in Volume 1, Section 2 Supra. Accordingly, the office did not charge any campaign associate or other U.S. person with conspiracy to defraud the United States based on the Russia-related contacts described in Section IV above. 2. Potential coordination. Foreign agent statutes, FARA and 18 U.S.C. Section 951. The office next assessed the potential liability of campaign-affiliated individuals under federal statutes regulating actions on behalf of or work done for a foreign government. A. Governing law. Under 18 U.S.C. Section 951, it is generally illegal to act in the United States as an agent of a foreign government without providing notice to the Attorney General. Although the defendant must act on behalf of a foreign government, as opposed to other kinds of foreign entities, the acts need not involve espionage. Rather, acts of any type suffice for liability. See U.S. States versus Duran 596 F3D 1283, 1293-94, 11th Circuit 2010, United States versus Lachin 554 F3D 709, 715, 7th Circuit 2009, United States versus Demisi 424 F3D 566, 581, 7th Circuit 2005. An agent of foreign government is an individual who agrees to operate in the United States subject to the direction or control of a foreign government or official. 18 U.S.C. Section 951D. The crime defined by Section 951 is complete upon knowingly acting in the United States as an unregistered foreign government agent, 18 U.S.C. Section 951A. The statute does not require willfulness, and knowledge of the notification requirement is not an element of the offense. United States versus Campa 529 F3D 980, 998 through 99, 11th Circuit 2008, Duran 596 F3D at 1291-94, Demisi 424 F3D at 581. The Foreign Acts Registration Act, FARA, generally makes it illegal to act as an agent of a foreign principal by engaging in certain largely political activities in the United States without registering with the Attorney General. 22 U.S.C. subsections 611 to 621. The triggering agency relationship must be with a foreign principal or a person of any of whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized in whole or in major part by a foreign principal. 22 U.S.C. Section 611CL. That includes a foreign government or policy party and various foreign individuals and entities. 22 U.S.C. Section 611B. A covered relationship exists if a person, quote, acts as an agent, representative, employee, or servant, end quote, or in any other capacity at the order, request, or under foreign principals' direction or control. 22 U.S.C. Section 611CL. It is sufficient if the person, quote, agrees, consents, assumes, or purports to act as or who is or holds himself out to be, whether or not pursuant to contractual relationship, an agent of a foreign principal, end quote. 22 U.S.C. Section 611C2. The triggering activity is that the agent directly or through another person in the United States, L, engages in political activities for or in the interest of the foreign principal, which includes attempts to influence federal officials or the public. 2, acts as public relations counsel, publicity agent, information service employer, political consultant for or in the interest of such foreign principal. 3, solicits, collects, disperses, or dispenses contributions, loans, money, or other things of value for or in the interest of such foreign principal, or 4, represents the interest of such foreign principal before any federal agency or official. 22 U.S.C. Section 611C1. It is a crime to engage in a willful violation of any provision of the Act or any regulation thereunder. 22 U.S.C. Section 681A1. It is also a crime willfully to make false statements or commissions of material facts in fair registration statements or supplements. 22 U.S.C. Section 618A2. Most violations have a maximum penalty of 5 years of imprisonment and a $10,000 fine. 22 U.S.C. Section 618. B, application. The investigation uncovered extensive evidence that Paul Manafort's and Richard Gates's pre-campaign work for the government of Ukraine violated FARA. Manafort and Gates were charged for that conduct and admitted to it when they pleaded guilty to superseding criminal informations in the District of Columbia prosecution. The evidence underlying those charges is not addressed in this report because it was discussed in public court documents and in a separate prosecution memorandum submitted to the acting Attorney General before the original indictment in that case. In addition, the investigation produced evidence of FARA violations involving Michael Flynn. Those potential violations, however, concerned a country other than Russia, i.e. Turkey, and were resolved when Flynn admitted to the underlying facts in the statement of offense that accompanied his guilty plea to a false statements charge. Statement of offense, United States versus Michael T. Flynn, number 117 CR 232 DDC, December 1st, 2017, document 4, Flynn statement of offense. The investigation did not, however, yield evidence sufficient to sustain any charge that any individual affiliated with the Trump campaign acted as an agent of a foreign principal within the meaning of FARA or in terms of Section 951, subject to the direction or control of the government of Russia or any official thereof. In particular, the office did not find evidence likely to prove beyond a reasonable doubt that campaign officials such as Paul Manafort, George Papadopoulos, and Carter Page acted as agents of the Russian government or at its direct control or request during the relevant time period. As a result, the office did not charge any Trump campaign official with violating FARA or Section 951 or attempting or conspiring to do so based on contacts with the Russian government or a Russian principal. Finally, the office investigated whether one of the above campaign advisors, George Papadopoulos, acted as an agent of or at the direction and control of the government of Israel. While the investigation revealed significant ties between Papadopoulos and Israel, and search warrants were obtained in part on that basis, the office ultimately determined that the evidence was not sufficient to obtain and sustain a conviction under FARA or Section 951. Number 3, campaign finance. Several areas of the office's investigation involved efforts or offers by foreign nationals to provide negative information about candidate Clinton to the Trump campaign or to distribute that information to the public to the anticipated benefit of the campaign. As explained below, the office considered whether 2 of those efforts in particular, the June 9th, 2016 meeting at Trump Tower, constituted prosecutable violations of the campaign finance laws. The office determined that the evidence was not sufficient to charge either incident as a criminal violation. A, overviewing of government law. The United States has a compelling interest in limiting the participation of foreign citizens in activities of democratic self-government and in thereby preventing foreign influence over the U.S. political process. Blumen versus FEC 800 F Sup 2D 281288 DDC 2011, Kavanaugh J for 3-judge court, affirmed 565 U.S. 1104 2012. To that end, federal campaign law, finance law broadly prohibits foreign nationals from making contributions, donations, expenditures, or other disbursements in connection with federal, state, or local candidate elections, and prohibits anyone from soliciting, accepting, or receiving such contributions or donations. As relevant here, foreign nationals may not make, and no one may solicit, accept, or receive from them a contribution or donation of money or other thing of value, or an express or implied promise to make a contribution or donation in connection with a federal, state, or local election. 52 U.S.C. Section 30121A1A2. The term contribution, which is used throughout the campaign finance law, includes any gift, subscription, loan, advance, or deposit of money or anything of value made by any person for the purpose of influencing any election for federal office. 52 U.S.C. Section 30101AAI. It includes, among other things, the value of volunteer services, 52 U.S.C. Section 30101.8bi. Foreign nationals are also barred from making an expenditure, independent expenditure, or disbursement for an electioneering communication, 52 U.S.C. Section 30121A1C. The term expenditure includes any purchase, payment, distribution, loan, advance, deposit, or gift of money, or anything of value made by any person for the purpose of influencing any election for federal office. 52 U.S.C. Section 30101.9AI. It excludes, among other things, news stories and nonpartisan get-out-the-vote activities. 52 U.S.C. Section 30101.9BIII. An independent expenditure is an expenditure expressly advocating the election or defeat of a clearly identified candidate and made independently of the campaign. 52 U.S.C. Section 30101.17. An electioneering communication is a broadcast communication that refers to a clearly identified candidate for federal office and is made within specified time periods and targeted at the relevant electorate. 52 U.S.C. Section 30104F3. The statute defines foreign national by reference to FARA and the Immigration and Nationality Act with minor modification. 52 U.S.C. Section 30121B, cross-referencing 22 U.S.C. Section 611B-I-3 and 8 U.S.C. Section 1101A 20 and 22. That definition yields 5 sometimes overlapping categories of foreign nationals, which include all of the individuals and entities relevant for present purposes, namely foreign governments and political parties, individuals outside of the U.S. who are not legal permanent residents, and certain non-U.S. entities located outside the U.S. A knowing and willful violation involving an aggregate of $25,000 or more in a calendar year is a felony. 52 U.S.C. Section 30109D, 1AI, see Blumen 800 F Sup 2D at 9292, noting that a willful violation will require, quote, some proof of the defendant's knowledge of the law, end quote, U.S. versus Danielsick, 917 F Sup 2D 573577 EDVA 2013, applying willfulness standard drawn from Bryan versus United States, 524 U.S. 184 191 to 92 1998. See also Wagner versus FEC 793 F3D 119 N23 DC Circuit 2015, and Blanc, same. A knowing and willful violation involving an aggregate of $2,000 or more in a calendar year, but less than $25,000 is a misdemeanor. 52 U.S.C. Section 30109D1A II. B, application to June 9 Trump Tower meeting. The office considered whether to charge Trump campaign officials with crimes in connection with the June 9 meeting described in Volume 1, Section IVA5 Supra. The office concluded that, in light of the government's substantial burden of proof on issues of intent, knowing and willful, and the difficulty of establishing the value of the offered information, criminal charges would not meet the Justice Manual standard that, quote, the admissible evidence will probably be sufficient to obtain and sustain a conviction, end quote, Justice Manual, Section 9 to 27220. In brief, the key facts are that on June 3, 2016, Robert Goldstone emailed Donald Trump Jr. to pass along from Amin and Aris Alagarov an offer from Russia's Crown prosecutor to the Trump campaign of official documents and information that would incriminate Hillary and her dealings with Russia and would be very useful to Trump Jr.'s father. The email described this as very high level and sensitive information that is part of Russia and its government's support to Mr. Trump, helped along by Aris and Amin. Trump Jr. responded, "If it's what you say, I love it, especially later in the summer." Trump Jr. and Amin Alagarov had follow-up conversations and within days scheduled a meeting with Russian representatives that was attended by Trump Jr., Manafort, and Kushner. The communications set up the meeting and the attendance by high-level campaign representatives support an inference that the campaign anticipated receiving derogatory documents and information from official Russian sources that could assist candidate Trump's electoral prospects. This series of events could implicate the federal election law ban on contributions and donations by foreign nationals, 52 U.S.C. Section 30121A1A. Specifically, Goldstone passed along an offer purportedly from a Russian government official to provide, quote, official documents and information to the Trump campaign for the purposes of influencing the presidential election. Trump Jr. appears to have accepted that offer and to have arranged a meeting to receive those materials. Documentary evidence in the form of email chains support the inference that Kushner and Manafort were aware of that purpose and attended the June 9 meeting, anticipating the receipt of helpful information of the campaign from Russian sources. The office considered whether this evidence would establish a conspiracy to violate the foreign contributions ban in violation of 18 U.S.C. Section 371, the solicitation of an illegal foreign source contribution or acceptance or receipt of an express or implied promise to make a foreign source contribution, both in violation of 52 U.S.C. Section 30121A1A.A2. There are reasonable arguments that the offered information would constitute a thing of value within the meaning of these provisions, but the office determined that the government would not be likely to obtain and sustain a conviction for two other reasons. First, the office did not obtain admissible evidence likely to meet the government's burden of proof beyond a reasonable doubt that these individuals acted willfully, i.e. with general knowledge of the illegality of their conduct. And second, the government would likely encounter difficulty in providing beyond a reasonable doubt that the value of the promised information exceeded the threshold for criminal violation. See 52 U.S.C. Section 30109D1A I. Thing of value element. A threshold legal question is whether providing to a campaign documents and information of the type involved here would constitute a prohibited campaign contribution. The foreign contribution ban is not limited to contributions of money. It expressly prohibits a contribution or donation of money or other thing of value. 52 U.S.C. Section 30121A1A.A2, emphasis added. And the term contribution is defined through campaign finance laws to include any gift, subscription, loan, advance, or deposit of money or anything of value. 52 U.S.C. Section 30118AI, emphasis added. The phrases thing of value and anything of value are broad and inclusive enough to encompass at least some forms of valuable information. Throughout the United States Code, these phrases serve as terms of art that are constructed broadly. United States versus Nielsen, 967 F2D 539542, 11th Circuit, 1992, per curiam. Thing of value includes both tangibles and intangibles. See also, e.g., 18 U.S.C. subsection 201B1 666A2 bribery statutes. In Section 641, theft of government property. For example, the term thing of value encompasses law enforcement reports that would reveal the identity of informants. United States versus Gerard, 601 F2D 6971, 2nd Circuit, 1979. Classified materials, United States versus Fowler, 932 F2D 306 310, 4th Circuit, 1991. Confidential information about a competitive bid, United States versus Matzkin, 14 F3D 1014 1020, 4th Circuit, 1994. Secret grand jury information, United States versus Jeter, 775 F2D 670 680, 6th Circuit, 1985. And information about a witness's whereabouts, United States versus Shecker, 618 F2D 607 609, 9th Circuit, 1980 per curiam. And in the public corruption context, thing of value is defined broadly to include the value which the defendant subjectively attaches to the items received. United States versus Renzi, 769 F3D 731 744, 9th Circuit, 2014, internal quotation marks omitted. Federal election, FEC regulations recognize the value to a campaign of at least some forms of information, stating that the term anything of value includes the provision of any goods or services without charge, such as membership lists and mailing lists, 11 CFR section 105(2)(d)(1). The FEC has concluded that the phrase includes a state-by-state list of activists. See Citizens for Responsibility and Ethics in Washington versus FEC, 475 F3D 337 338, DC Circuit, 2007, describing the FEC's findings. Likewise, polling data provided to a campaign constitutes a contribution. FEC Advisory Opinion 1990 through 12 Strube 1990 WL 153454, citing 11 CFR section 1064B. And in the specific context of the foreign contributions ban, the FEC has concluded that election materials used in previous Canadian campaigns, including flyers, advertisements, door hangers, trifold signs, and other printed material, constitute anything of value, even though the value of these materials may be nominal or difficult to ascertain. FEC Advisory Opinion 2007 through 22, Hurwitz, 2007 WL 517237, 5 at 5. These authorities would support the view that candidate-related opposition research given to a campaign for the purpose of influencing an election could constitute a contribution to which the foreign source ban could apply. A campaign can be assisted not only by the provision of funds, but also by the provision of a derogatory information about an opponent. Political campaigns frequently conduct and pay for opposition research. A foreign entity that engaged in such research and provided resulting information to a campaign could exert a greater effect on an election and a greater tendency to ingratiate the donor to the candidate than a gift of money or tangible things of value. At the same time, no judicial decision has treated the voluntary provision of uncompensated opposition research or similar information, such as a thing of value, that could amount to a contribution under campaign finance law. Such an interpretation could have implications beyond the foreign source ban, see 52 U.S.C. section 30116A, imposing monetary limits on campaign contributions, and raise First Amendment questions. Those questions could be especially difficult where the information consisted simply of the recounting of historically accurate facts. It is uncertain how courts would resolve those issues. Willfulness. Even assuming that the promised documents and information that would incriminate Hillary constitute a thing of value under campaign finance law, the government would encounter other challenges in seeking to obtain and sustain a conviction. Most significantly, the government has not obtained admissible evidence that is likely to establish the sciencer requirement beyond a reasonable doubt. To prove that a defendant acted knowingly and willfully, the government would have to show that the defendant had general knowledge that his conduct was unlawful. U.S. Department of Justice Federal Prosecution of Election Offenses 123, 8th edition, December 2017. Election Offenses, see Blumen 800 F Sup 2D at 292, noting that a willful violation requires proof of the defendant's knowledge of the law. Daniel Sec 917 F Sup 2D at 577, knowledge of general unlawfulness. This standard creates an elevated scienter element requiring, at the very least, that application of the law to the facts in question be fairly clear, When there is substantial doubt concerning whether the law applies to the facts of a particular matter, the offender is more likely to have an intent defense, election offenses 1, 2, 3. On the facts here, the government would unlikely be able to prove beyond a reasonable doubt that the June 9 meeting participants had general knowledge that their conduct was unlawful. The investigation had not developed evidence that the participants in the meeting were familiar with foreign contributions ban or the application of federal law to the relevant factual context. The government does not have strong evidence of surreptitious behavior or effort at concealment at the time of the June 9 meeting. While the government has evidence of later efforts to prevent disclosure of the nature of the June 9 meeting that could circumstantially provide support for a showing of scienter, see Volume 2, Section 2G, Infra, that concealment occurred more than a year later, involved individuals who did not attend the June 9 meetings and may reflect an intention to avoid political consequences rather than any prior knowledge of illegality. Additionally, in light of the unresolved legal questions about whether documents and information of the sort offered here constitutes a campaign contribution, Trump Jr. could mount a factual defense that he did not believe his response to the offer and the June 9 meeting itself violated the law. Given his less direct involvement in arranging the June 9 meeting, Kushner could likely mount a similar defense. And while Manafort is experienced with political campaigns, the office has not developed evidence showing that he had relevant knowledge of these legal issues. Difficulties in valuing promised information. The office would also encounter difficulty proving beyond a reasonable doubt that the value of the promised documents and information exceeds the $2,000 threshold for a criminal violation, as well as the $25,000 threshold for felony punishment. See 52 U.S.C. Section 30109D1. The type of evidence commonly used to establish the value of non-monetary contributions, such as pricing the contribution on a commercial market or determining the upstream acquisition cost or the cost of distribution, would likely be unavailable or ineffective in this factual setting. Although damaging opposition research is surely valuable to a campaign, it appears that the information ultimately delivered in the meeting was not valuable. And while value in a conspiracy may well be measured by what the participants expected to receive at the time of the agreement, see e.g. United States versus Tombello 6XS F2D 489 11th Circuit 1982, Goldstone's description of the offered material here was quite general. His suggestion of the information's value, i.e. that it would incriminate Hillary and would be very useful to Trump Jr.'s father, was nonspecific and may have been understood as being of uncertain worth or reliability given Goldstone's lack of direct access to the original source. The uncertainty over what would be delivered could be reflected in Trump Jr.'s response. "If that's what you say, I love it," emphasis added. Accordingly, taking into account the high burden to establish a culpable mental state in a campaign finance prosecution and the difficulty in establishing the required validation, the office decided not to pursue criminal campaign finance charges against Trump Jr. or other campaign officials for the events culminating in the June 9 meeting. C, Application 2. I, questions over whether willfulness. As discussed, to establish a criminal campaign finance violation, the government must prove that the defendant acted knowingly and willfully. 52 U.S.C. Section 30109D1AI. That standard requires proof that the defendant knew generally that his conduct was unlawful. Election offenses 1, 2, 3. Given the uncertainties noted above, the willfulness requirement would pose a substantial barrier to prosecution. I, constitutional consideration. Finally, the First Amendment could pose constraints on a prosecution. IV, analysis as to false statements and obstruction of the investigation. The office determined that certain individuals associated with the campaign lied to investigators about campaign contacts with Russia and have taken other actions to interfere with the investigation. As explained below, the office therefore charged some U.S. persons connected to the campaign with false statements and obstruction offenses. A, overview of governing law. False statements. The principal federal statute criminalizing false statements to government investigators is 18 U.S.C. Section 1001. As relevant here under Section 1001A2, it is a crime to knowingly and willfully make any materially false, fictitious, or fraudulent statement or representation in any manner within the jurisdiction of the executive branch of the government. An FBI investigation is a matter within the executive branch's jurisdiction. United States versus Rogers, 466, U.S. 475, 479, 1984. The statute also applies to a subset of legislative branch actions viz. Administrative matters and investigations or reviews conducted by a congressional committee or subcommittee. 18 U.S.C. Section 1001, C1 and 2, see United States versus Pickett, 353 F3D 6266, D.C. Circuit, 2004.